all of you that are just joining us. We're going to get started momentarily in about 2 minutes. We'd like to start right on time, but let's just give folks some time to log in. We do ask you that you please remain muted and your videos off throughout this webinar this morning. And I'm an event coordinator for the Worcester Regional Chamber of Commerce. I'd like to welcome you all this morning to the Chamber's webinar series, which is greatly sponsored by Fallon Health. We're going to start momentarily. I just have a couple little housekeeping rules for everybody. Probably all of us know these by now, but we ask you to please have your videos and your sound off, just in respect our presenters this morning, and it doesn't have any distractions on the side or noise. We also are recording this webinar, so for any of those that would like a copy of it later, you can reach out to me and I'd be more than happy to send you a copy of this recording. And so without further ado, the Chamber is very grateful for Fallon Health for sponsoring this webinar series this year. So I'd like to welcome you, Melissa Randall. She's the Corporate Communications Manager for Fallon Health. Melissa?
Well, good morning, everyone. And thank you, Lily, for that warm introduction. It is great to be here with all of you today. On behalf of Fallon Health, welcome to the webinar. Fallon is really pleased to support the Chamber's free webinar series. Now more than ever, resources like this one are so valuable. And this is just one of the many ways in which we have been taking steps over the past several months to support our customers as well as the broader community during the pandemic. We applaud the Chamber for all that it is doing to support the business community during these challenging times. As you know, the webinar series is designed to provide relevant information, and I'm glad to see so many people tuned in today to learn about these new regulations surrounding the Paid Medical Leave Act. 2021 is right around the corner, thankfully, am I right? And we all have so much to learn on this important topic before then. With that, I'd like to turn it back over to Lily so we can get things started. And again, on behalf of Fallon Health, thank you so much for joining today. Lily?
Well, thank you, Melissa. Thank you to Fallon for always being there and supporting the community, and especially us at the Chamber. At this moment, I forgot to mention that we will be doing Q&As for our presenters this morning on this topic. I'm sure you guys have a lot of questions to ask. So at the bottom of your screen, there's a chat box. Please refer to that chat box when asking questions. We will be monitoring that, and we will be asking Q&As at the end of the presentation. We will have a hard stop at 11 a.m. as planned. And for those of you that would like to remain on for an extra couple of minutes, our speakers are going to stay on just to make sure that we answer all your questions. So without further ado, I'd like to introduce to you the two attorneys that are going to be speaking to you this morning about the Paid Family Leave Act, and that's Dee Moskows and Kimberly Brozak from Merrick O'Connell. Welcome, Dee and Kim.
Thank you.
Good morning.
Good morning. Kim and I are attorneys at Merrick O'Connell. We practice labor and employment law, and this is actually the third series of seminars that Kim and I have done for the Chamber in connection with this act. And so that some of this, for those of you who have attended previously, it may be a refresher. But the act does go into full effect on January 1st. And so Kim and I would like to present you with the present state of the regulations of the act. And Kim will begin, and then we're going to go back and forth on the slides. If you have specific questions, please go into the chat room and provide those questions. So without further ado, I introduce my partner, Kim Brozak.
Good morning, everyone. Thank you, Dee. And I do want to thank the Chamber. Thank you, Lily. And I'd like to thank our sponsor, Fallon, for allowing us to put this seminar on for you folks this morning. And as Dee said, knowing that the statute's benefits begin in a few months, it's important to kind of put this in the forefront. We've been thinking too much about a pandemic. Let's move forward. So on slide 1, as you can see, this really high overview here, you're going to see PFML a lot, and it stands for the Paid Family and Medical Leave Law that was passed and begins, as I said, early next year on January 1st. And it provides up to 26 weeks of leave in a benefit year, and it's paid. Okay, so that's important. It's paid leave. Everyone knows that. You've been paying into a trust fund by now, and it's for individuals who work in Massachusetts and meet certain eligibility requirements. If people have questions later about what it means to work in Massachusetts, the regulations implementing this law were put into effect in July, and we're still working through those. So, you know, at high level, we're going to keep moving forward. Next slide. Thank you. The PFML is different from FMLA in a number of ways outlined on this slide. I'm just going to highlight a couple of those. Number one, an employee who's eligible for this benefit can get up to 26 weeks of leave. So they can combine the kinds of leave that is eligible. So under the law, later on, people probably know this, but under the law, there's different grounds or reasons for using this kind of leave. And you can get up to 26 weeks of paid leave here, whereas the FMLA, importantly, is not paid, and it's only 12 weeks of leave. 26 only for leave to care for a service member. As I said already, this applies to all Massachusetts employers, regardless of size. But the FMLA only applies to employers of 50 or more. There is no waiting period at all for this benefit, which is going to be used, I think, frequently, unlike the FMLA, again, where you have to be employed at least 12 months before you have the right to use the benefit. There is a bit of an earnings requirement there. It's on the on the slide here, 5,100 in the last 12 months, whereas FMLA does not require any earnings requirement. Definition of family is broader under our state law than the federal law. Employers have to collect a contribution because, again, it's paid, as opposed to the federal law, which is not paid, so there's no contributions. We could go to the next slide. I think Dee is going to take over from here.
The law is similar to the unemployment insurance requirements, and you'll notice as we go through the slides some similarities. The key point from this slide is one dealing with the notice. You have to post a notice in the workplace, and there is a notice that the department has issued. In addition, you need to give all employees written notice of the law. Under the present regulations, that notice should already have been given to your current employees. So hopefully that has been accomplished. And all new employees coming on should be in their orientation period, be given the notice under the Act. So the key point in this slide is you need to give notice to the employees of the Act. Next slide. This next slide deals with the contributions. The employer is being assessed 0.75% of the payroll for the contributions under this program. There is a ceiling of $137,000 where after that point, you no longer have an assessment applicable. That ceiling is the same ceiling for Social Security. So when the Social Security tax is adjusted annually because of the cost of living, you will see the ceiling being increased automatically under the State Act. Now, this Act has an interesting items here. The employee is participating in the cost of the Act. On the family leave, they have allocated 0.13% for the assessment, and you can deduct that completely from the employee's pay. In addition, on the medical leave end, which they've allocated 0.62% of the eligible wages, you can deduct 40% of the cost of that contribution. But the contribution requirement is on the employer, not on the employee. So you need to go through and make those deductions. Some employers are not charging their employees for participating in the program, and that is allowed under the Act. But legally, you have the right to do those deductions. So 100% requirement for the employer to pay the state, the employer may get deductions from the employee. Next slide. There is a break in this act, even though Massachusetts is a blue state, there is some consideration for small employers. The small employers are not required to pay the employer's share. And that means employers are defined as less than 25 employees. However, the employee share has to be contributed by the employees, and the responsibility for collecting that and paying that by the small employer is the small employer. So that if your company is less than 25 employees, you must pay 0.13% of the family leave and 0.248% of the medical leave from the employee, and then contribute that to the state. A point I wanted to make about the 0.75%, that figure will be adjusted annually depending on the trust fund's status. So that that is not a fixed statutory amount. It will be adjusted by the department to meet the contributions requirement out of the trust fund. Next slide.
Okay, so on this slide, we're talking about how you calculate the workforce for purposes of determining who's actually eligible for benefits. So for employers, and I'm assuming that, and unfortunately we're not live, so I don't have a show of hands or whatnot, but I'm assuming most of you participating today fall under the category of employer. And in terms of determining who your total workforce consists of, it's pretty straightforward. It's basically everyone who is an employee and receives a W-2 from the business. So it's your full-time employees and part-time employees and seasonals, everyone who's on the payroll. Now the slide interestingly has some math here, and it talks about divide by number of pay periods. That probably shouldn't be on the slide, because that then gets into the calculation of how much is to be deducted. So there's kind of a combination of information here, but in terms of who's on the workforce for an employer, it's all employees, as I said. And if you divide by the number of pay periods, that tells you how much you're going to be calculating and paying over to the trust fund. Then there's the category of covered business entities. So what is that? Those are businesses that contract with self-employed individuals and report payments on a 1099 for more than 50% of their workforce. And if you say to yourself, who are these people? Because even I wasn't sure, who are these business entities? Dee aptly explained to me that it's really the real estate brokers. So they kind of got a break here in Massachusetts. Your real estate agents, they are not independent contractors. They're deemed to be self-employed individuals. So if you've got like your commercial real estate entity, more than 50% of their workforce are going to be paid with a 1099. Those are the people that this covered business entity is applying to. And there and obviously you say you have a commercial real estate organization, they're going to have in-house employees as well, your front office, administrative staff, or whatever. So for purposes of determining who's part of that business entity, you're adding up your number of employees as calculated under the first bullet point, and the number of self-employed individuals. And again, the self-employeds need to be more than 50% of the workforce. And again, the slide is referring to divided by the number of pay periods. That really goes to the calculation of what goes into the trust fund, not the actual calculation of the workforce. And then right now, I think everybody has been operating under the total workforce. You've been using figures from 2018. The reason you've been doing that is because the law, contributions began in 2019. So you had to determine what your workforce was in 2019. So we were using the 2018 workforce. Beginning next year, when we are hopefully all in a new world again, you will be using the previous year's workforce to determine the number of people based on whom you're supposed to be making the deductions. So as I said, currently you're using 2018, beginning next year, it'll be 2020. Next slide. So I don't know how many of you out there may arguably be excluded. And if you are, and you're just listening in because you're thinking you might want to opt into this law, okay? But statutory exclusions, so employers that are not part of this statute are municipalities, districts, political subdivisions, housing authorities, regional school districts, and so forth, just as the bullet point says. Now, the statute doesn't say, and neither does the regulations, but there are other exclusions. Churches, certain religious organizations are excluded, railroad industry, and work that is performed for a son, daughter, or spouse, or if under 18, for a father or mother. And you may be saying, where do these come from? It is because the definition of employer in this statute comes from really the Unemployment Act, which is General Laws Chapter 151A. So the unemployment law defines who an employer is. This law uses the same definition. So we've got those exclusions. And as I say, several of them are not mentioned in the regulations, but they are excluded from the law because they wouldn't apply in unemployment. Next slide.
This slide here talks about the amount that would be subject to the tax. And I want to point out two things. Severance pay, which is given in exchange for a release, is not subject to the tax. And that follows the unemployment law, which provides that if you get severance pay and you've given a release to the employer, you are still eligible for unemployment. So as we pointed out earlier, and as Kim just pointed out, this law in many ways is parallel to the unemployment law. At the bottom of the slide, look at the limit that I mentioned earlier. 137,700 is the Social Security limit for taxes. This is on the basic Social Security. Obviously, the Medicare, which is different, doesn't have that ceiling, but this is the ceiling, and this will be adjusted every year. Next slide. The question of who is eligible, as Kim mentioned, it's almost everybody is eligible, and this follows similarly to the unemployment. You have to have at least earned $5,100 in the previous 12 months. The interesting point on this slide, which has surprised a lot of people, is the fact that if you have laid off an employee during their unemployment compensation period, they are also eligible for this law, because in Massachusetts, we provide unemployment compensation for 26 weeks. So during that period of time, they are eligible to be covered by this law. As Kim mentioned about the independent contractors, they are included in the particular coverage if they're more than 50% of the employer's workforce. Let me just mention about the independent contractors law, because employers need to be sensitive to that law. In Massachusetts, to be classified as an independent contractor, you have to be a person not under the control of the employer, not performing the same service as the employer. And thirdly, you have to be one engaged in a business of providing independent contracting services to other employers. That's a tough test. It's called the ABC test. That's a tough test to meet. And so it's very limited today, and when individual employees can be classified as an independent contractor, as Kim mentioned, there's an exemption for real estate brokers. Next. As I mentioned, who are these independent contractors? They must live in the Massachusetts, perform services in Massachusetts, and receive payments under the 1099 form. Also, they have to constitute 50% of the workforce of the employer in order to be subject to this particular law. Next.
Okay, so amounts of leave. So there are here, we have 5 different categories. You've got family leave. So an employee would be entitled to up to 12 weeks of this kind of leave for the birth, adoption, or foster care placement of a child, very similar to the FMLA, in which case we talk about a lot of these laws running concurrently. We'll get to that later, but this would be an example. Then there is family leave allowed, again, up to 12 weeks on the basis of a qualifying exigency that arises out of the fact that a family member is on or will be on active duty in the armed forces. Again, family leave, but this time up to 26 weeks to care for a family member who is a covered service member. This again is similar to the FMLA, where an employee who's eligible for FMLA would get up to 26 weeks of leave to care for a service member. There's family leave to care for a family member with a serious health condition. That's up to 12 weeks, but this, for whatever reason, does not go into effect until July 1 of next year. The others go into effect January 1. And then finally, there's medical leave for the employee's own serious health condition. Now, this is up to 20 weeks. So this is, you know, considerably longer than what you would pay under FMLA, or what you would experience under FMLA. And I said pay if someone's going to be using their own leave. Next slide. Each one of the following slides goes into more detail about the basis for leave. I don't know that I want to spend a lot of time on these, because these bullet points are fairly self-explanatory. As I said, in terms of birth, adoption, and foster care, the only real difference here is that it's quite clear that the leave must be taken during the first 12 months after a child's birth, adoption, or foster care. That's more generous, really, than I think what most people do, which is to take the leave right away. So this would be a situation maybe where the father decides that he is going to take leave, you know, sometime after mom gives birth, and it's going to be down the road, and then they can take up to 12 weeks. And we have intermittent leave is allowed if the employer and the employee agree upon it. So that's important. It's not an absolute permission or authorization to do so, but there needs to be an agreement on the use of intermittent leave under these circumstances. And then we have the definitions of adoption and foster care. Next slide. So this is the leave that an employee can take up to 12 weeks when there is a qualifying exigency, which is related to, you know, someone in the household either being called up to military duty or is in the armed forces. And again, all of this is sort of self-explanatory, but I want to call your attention to one of the bullet points, not the last one, but the one before that. And I think this is interesting. So as the regulations are written, it allows an employee up to 12 weeks of time off, paid, now remember paid, so as to spend time with the military member during rest and relaxation, that's fine. R&R usually, D can tell me better. He was in the service, and thank you for that. But, you know, maybe 2 weeks. But following return from deployment. So when your family member comes home, you would technically be allowed to take up to 12 weeks off. So I just point that out. I'm thinking it might be used. Next
Kim,
slide.
it's true. You get 30 weeks, 30 days of annual leave. So it could be 30 days.
For the R&R.
An R&R.
Okay, so you get that, but then as I'm noticing
That's
is
the
this,
military member. The military member gets 30 days.
right,
So family member will get
that much time.
okay.
And
Right.
then when they're finally out, it would let's be a new benefit year by then, and then you'd be entitled to up to 12 weeks. Just pointing that one out. So we're on slide 15. Leave to care for a service member. This allows up to 26 weeks of time off, and the definition of a covered service member is here on the slide. And this is a situation though where you are caring for somebody who has a medical need. Next slide. Leave to care for a family member who has a serious health condition. We have the definition of serious health condition here, and intermittent leave is allowed if the healthcare provider determines that it is medically necessary. So under these circumstances, the employer would have to allow intermittent leave so long as the healthcare provider indicates that that's what is required. And again, this form of leave is available for up to 12 weeks. And the last, next slide, and the last, to treatment by a healthcare provider, we've got some definitions here. I think each of you can read these, at least 3 consecutive days of treatment for a period of incapacity. It can be due to pregnancy or prenatal care, so that would qualify as a serious health condition. So if family member could be caring for someone with, who is pregnant. Chronic serious health condition, which is one that requires treatment at least 2 times a calendar year and continues over an extended period of time. And naturally for conditions that require multiple treatments, surgery, and so forth. So again, the definitions are self-explanatory in terms of the treatment that needs to be provided to the individual. Next slide. The serious health condition does not include cosmetic surgery unless that there is a complication. So that would be if there's a bad outcome on your cosmetic surgery or elective surgery, then it would qualify for a serious health condition to allow an employee to be out to care for the family member. And then the last bullet point here, I will just call to your attention. If an individual is ill because of a substance abuse disorder, the employee cannot use this form of family leave to be out to care for the person because they are actively ill with the disorder. But if the disorder itself is being treated and the person is either in outpatient treatment or inpatient treatment and there's need periodic care or needs consistent care at home if they are at home, then in other words, if the substance abuse disorder is being treated, the employee would qualify for family leave, but not if basically the person's on a binge and not doing well. So they've got to be in treatment in order for the family member to be able to take leave related to a substance abuse situation. Next slide. So the last category of leave is for an employee's own serious health condition, and intermittent leave may be taken here again if medically necessary. The individual must inform the employer of the reason why the intermittent leave is necessary and what the schedule of treatment will be. And then the individual and the employer will work out a schedule for intermittent leave that meets the employee's needs. So again, this is a situation where the employer does have to provide intermittent leave, but there needs to be a discussion and an agreement between your employer and employee as to how the leave would be taken. This is under these circumstances, remember, an employee can be out for up to 20 weeks for his or her own serious health condition. And keep in mind, before I turn the slide, keep in mind that it's a 26-week benefit year benefit. So the benefit year is defined to be the first time an employee invokes the use of paid family medical leave. So for the next 52 weeks, the employee is entitled to use up to 26 weeks of leave. And again, it can be a combination of any of these that I just reviewed. And there doesn't have to be another 52, well, then the next benefit year starts 52 weeks after that. So arguably, every 52 weeks in succession, there could be a combination of leaves of up to 26 weeks, just in terms of how the law works. Next slide.
The next slide refers back again to this notice situation. Now it's in the connection with the employee giving notice to the employer. And the Act talks about giving at least 30 days notice if it's anticipated. Obviously, if someone is sick, usually you will not have that type of 30-day notice unless there's some type of surgery that can be scheduled. And the Act also talks about the fact that in the regulations that the employer should follow your procedures of how you give the notice relative to telling the employer that you wish to take this leave. Go to the next slide, please. The employee, after they've given appropriate notice, then would file an application with the Department of Family Medical Leave, and they cannot file it earlier than 60 days, within the 60-day period that they file for that particular leave. Next slide, please. An important item here is this fact, once the application is filed with the department then would be asking for information like under unemployment from the employer. And the employer has, like unemployment, 10 business days to respond to that request for information. So that you need to get your department that provides the unemployment notice to also be geared up to be responding similarly to the Family Medical Leave Department. Next slide, please. Under the regulations, the 14 days after the employee has put forward the application, the department will notify the employee of whether they have been approved for the leave. And the department is supposed to start payments 14 days thereafter. Hopefully that the department will have the sufficient staff to do that. As we have found in unemployment, the payments have been delayed. So it's 14 days notice from the department and then 14 days afterwards. Look at the note at the bottom. This is an important...
Can I just interrupt for a second, Dave? I apologize. I think we need to be on the slide before this one in terms of if folks are following along. There you go. Thank you. Go ahead.
Thank you. Look at the note at the bottom. That's a very important note. You have 10 days after the employer receives notice of the approval to give the employee a list of the essential functions of their job. That applies to whether you can require a fitness for duty certification for the employee to come back to work. If you fail to give this 10-day notice of job functions, essential job functions, you will not be allowed to require fitness for duty certification. So many employers, particularly the smaller ones, don't have job descriptions. And so we really have 60 days now, a little more than 60 days, to get your job descriptions up to date so that they reflect the essential functions of the job. And if you wish to have some control of people returning to work relative to their ability to perform the job after they have been out for up to 20 weeks relative to an illness. So this is a critical point that Kim and I want to emphasize about that this 10-day notice of job functions needs to be sent to the employee within that 10-day period. Next slide, please. The law, like unemployment, has a 7-day waiting period, and that you're not eligible for benefits for that 7-day period. You have, however, and we're going to, at the end of our presentation, we're going to talk about the 2 other leave acts that Massachusetts has relative to the Massachusetts sick law. As you know, Massachusetts requires all employers to provide paid sick leave of up to 40 hours. And so that will be able, the employee will be able to use, he hasn't already used up that time, to cover that 7-day waiting period. And then, of course, they would be eligible for the money under the 20-week period. So that there's a 7-day waiting period. The other point, and we don't have time to go through the formula of this. You can read it. There's an example explaining how it is there. There's a cap of $850 a week. That cap is subject to an annual adjustment. It's our understanding that they're not adjusting it this year. And so, but that's still the ceiling. The most that the person can get paid under the act is $850. Next slide.
Okay, so benefits during leave, and what this slide gets to is the benefits that an employee already has earned or accrued through his or her employer. So employees who take leave under the PFML, taking this leave may not affect their right to accrue any of their regular benefits, such as vacation, sick, bonuses, or other, employment benefits upon reinstatement. So this is important to keep in mind, that when a person or employee uses the leave under the law, when they're reinstated, the leave ends and they come back to work, they can't lose any of their accrued benefits. So they have the same vacation, sick leave, and so on. However, under the next bullet, you'll notice that for leave periods that the person is out on paid family medical leave, benefits do not need to continue to accrue. So for example, if someone had 10 days of vacation leading up to a period of leave under the statute, they would have that same amount available to them, but they don't need to continue to accrue. Unlike, usually if someone's on vacation for a week or 2 weeks, you're not going to stop allowing them to accrue vacation if they accrue it weekly, or if they accrue it monthly, they're going to continue to accrue at the same rate. But periods of PFML leave, you don't accrue. However, both employer and employee must continue to provide for and contribute to health insurance benefits that are in effect. And the reason why an employer has to contribute, yes, but the reason why the employee or the covered individual has to continue to provide health insurance or to provide premiums towards health insurance is because they're getting paid. So you, unlike unpaid leave under the FMLA, where we often get questions from our clients, well, so-and-so is now out, it's the, you know, third month under FMLA, they ran out of leave benefits, they're not getting paid, they still have job protection to return to work at the end of the 12 weeks, but they don't have any money to deduct in order to get paid you know, premium contributions towards health insurance. Here, at least the employee has money. Now, money is being paid by the state, admittedly, but at least there is money being paid and you can make arrangements with the employee to continue to receive employee contribution during the time of their PFML leave. Next slide. So, this slide talks about how statutory leave runs concurrent with leave under the PFML. So if an employee is on paid family medical leave for any of the reasons, whatever statutory rights they would have, if the statute, you know, during that same time, those will run concurrent. And this is taken immediately out of the regulations. And it says right in the regulations, the same thing that the slide says, that if an individual is out because they gave birth to a child or they are adopting or fostering, that is covered by the Massachusetts parental leave law. And it is also covered by FMLA. So while a person is on PFML, it is also running their leave under the Massachusetts parental leave law and the FMLA if the FMLA applies to you. So they don't get an extra benefit at the end. So in other words, if they're going to get 12 weeks under PFML for the birth of a child, they're not going to then get another 12 under FMLA. So they're running concurrent. The one significant exception, which does not show up in the regulations, but I'm quite confident that it is an exception to this slide, is the Massachusetts earned sick time law. So Dee just referred to it when he said the first 7 days of leave under PFML is not paid. It counts towards the, you know, the week of leave, but it's not paid. So if an employee has leave available under the earned sick time law, they can use it if they want to, or they can go unpaid. An employer cannot require them to use their earned sick time to fill in the unpaid leave for the first 7 days. As I said, they can save it, they can use it. But the earned sick time law, I think, is the one that lawyers have been discussing, does not run concurrent with these leave laws. And as I say, it's not in the regulations, but it has been talked about with the state. The state is holding periodic meetings with attorneys to try to work out the regulations, because frankly, everything isn't smooth yet. We're hoping for a smoother resolution to some of the issues, but that's one of them. And I wanted to point that out. Next slide. Job restoration. So just like if an employee was on FMLA, at the conclusion of their leave, they shall be restored, not may be or should be, but shall be restored to their previous position or an equivalent position with, as I said, same status, pay, employment benefits, etc. Unless, and there is an unless here, similarly situated employees have been laid off due to economic conditions or changes in operations. So again, this is like the FMLA. If you administer the FMLA and you conducted a layoff of employees in a particular job group, an employee who is on PFML during that time could also similarly be laid off. I'd be careful though, because there is, later on in the slides, you'll see there's a you know, concern about any negative action taken against employee being retaliation for having used the benefit. But I think it's pretty clear if there was a, you know, a universal layoff in a particular job group and someone was on PFML, they don't have to be restored to work. They're going to continue to get paid by the state though during the period of their leave. And the other exception to job restoration is if a person was hired for a specific project and that term is over. Next slide. Dee just mentioned, importantly, this fitness for duty certification. So I'm not going to really go over this again, knowing that we want to leave some time for questions. But as he said, it is critical that employers provide employees within 10 days of notice. They got to have within 10 days of going out on leave that, hey, here's a list of your essential job functions, and we want to be sure that you have them. And in that way, an employer will be allowed to request a fitness for duty certification from an employee when they come back to work. And if you have provided the job list of essential job functions and the employee has not been cleared to return because they don't have a certificate from their physician or healthcare provider, you can delay restoring them until there is a certification. And like the FMLA, the last bullet point here says an employer can require certifications for intermittent or reduced schedule leave only one time every 30 calendar days, and only if reasonable safety concerns exist regarding the individual's ability to perform their duties. So this is a situation primarily if you've got someone on intermittent leave or reduced schedule, as it says, you may be concerned that they have up to 20 weeks of leave for their own serious health condition and they're spreading it out. You can every 30 days do a check-in with them, but it has to be if reasonable safety concerns exist. So they're coming to work periodically. Maybe they have a back injury and you've readjusted their work schedule somehow, but you're concerned that you want to make certain they're able to continue to perform the functions that they're doing currently. Every 30 days, you can do request a certification. Next slide. Here's the anti-retaliation provision that I just mentioned. And there is a presumption, and this is also sort of a critical point to this law. There is a presumption that any negative change in an employee's, work status or benefits, or if someone has been written up for, absenteeism or a pattern of tardiness, that the employee says, well, you wouldn't have done this to me before, or you haven't called other people out on it. There is a presumption under this law that if the person used leave under this statute, that for the next 6 months when they're restored to work, there's a presumption that anything negative done to or said to the employee is as a result of the fact that they took leave under the PFML and it's treated as retaliation. Now, the regulations do say that it cannot be a de minimis type of negative change. It has to be substantive and material. But what's also interesting here is that in order to overcome the presumption, the employer needs clear and convincing evidence that the action had sufficient independent justification. Clear and convincing is important because the standards that we typically operate by is by a preponderance of the evidence. So by law, the standard is higher. And Dee and I often explain to our clients, the preponderance of the evidence is 51%. So if you can show by 51% that you did what you did for a legitimate business reason, you're okay. Clear and convincing, that's more than 60%, could be as much as 70%. It depends on who's making that judgment call. So you have to have, and this is where it's critical, people, document why you're doing something. Document why you make a change, document why you have a write-up for someone, make clear that there is independent reason for what you're doing. Don't just talk to somebody, document it. Next slide.
Real quickly, because we are running out of time, the triple damage law does apply here and attorney's fees if you do not give proper information, for example, to the state. You could have a attorney claim that the person was underpaid for the period of time that they were on this leave, and that they could argue that they should get triple damages because of that lost income. Next slide. The point here is that if you go out on your own paid leave because it pays more than the $850 a week that you can achieve under the state law, you cannot piggyback that. In addition, if the employer has they have, for example, their own self-disability plan, they can get reimbursed from the state for payments up to the level the state would have paid for that particular plan. Next slide.
Can I just make sure that people understand under the second bullet, it's not insurance plan. So if you have an insurance short-term disability plan, that's not what this slide speaks to. It speaks to an employer paid policy plan.
Good point, Kim. Written notice, again, about the fact that we've emphasized this before, that you have to give employees notice of the benefits under this law. We're going to, because of time, skip the slides to go to page 36. So if we could go to page 36.
If people have questions about private plan approval, that's probably a separate conversation. And although I know a number of employers considered it early on, I'm not too sure how many are actually doing it. So we are just going to move forward.
We could go to slide page 36, the summary of the Massachusetts sick leave law. As Kim and I indicated, we have the Massachusetts paid medical leave law. We also have in Massachusetts, that I think almost everybody is aware of, the sick leave law, which is mandatory in all employers in Massachusetts, irrespective of size. The law provides that for every 30 hours of actual work, employee earns 1 hour of paid sick leave if they're over 11 employees, and to a maximum of 40 hours per year. The eligibility for this sick leave under these is much broader than normal, as explained in the slide. It also covers medical appointments. It covers the employee, employee's children, employee's spouse, and employee's parents. Also, there's a restriction on documentation. The law does not permit you to require a sick leave note, for example, unless there's been 3 consecutive days of sick leave. There is a benefit, however, in the law that if you have less than 11 employees, they're entitled to the sick leave, but it may be unpaid. The employer does not have to pay for that law. Also, there's a good benefit in the last bullet here on page 37. The employer may delay new employees' use of paid sick leave for 90 days. So if you have seasonal employees, for example, that come in, even though technically they will be earning 1 hour for every 30 hours of work, if they are only employed for 80 days, for example, then they leave, this law does not require the employer to pay for sick leave that the person had earned upon their departure. It's not a vested benefit like vacation. And so therefore, this provision was intended to provide some flexibility to employers for seasonal employment. So you can delay the taking of the sick leave for 90 days. And if I'm repeating myself, but for 90 days, and if the employee leaves prior to the 90 days, then you do not have to cash out that leave, and the employee does not get any payment for sick leave. They would get payment for vested vacation, but not for sick leave. Kim?
Okay, next slide, please. And I'll just quickly mention that, as you know, the Massachusetts has Small Necessities Leave Act, which is available to employees of employers 50 or more, employers that have 50 or more employees. And this benefit is different than FMLA in terms of the reasons why you are eligible for it. It's 24 hours of leave annually allowed to employees for the specific reasons under the law. It is not paid leave. I mean, you could probably substitute vacation if you wish to, or personal leave. Ordinarily, an employer would allow you to do that, but by statutes, it's not paid. And this kind of leave would not run concurrent with PFML because it's used for different reasons. You know, it's for allowing an employee to participate in a son or daughter's school activities, parent-teacher conferences, to accompany elderly relatives to medical appointments, or you know, review care facilities and so forth. An employer can require an employee to use their accrued paid leave to substitute for the unpaid leave. And as I said, otherwise it's not paid under the law. And use of small necessities leave can be intermittent in increments of 1 hour or more. That's on the next slide. And that's just a refresher to remind employers that, yes, there is the Small Necessities Leave Act out there, which I think a lot of them forget about. So this brings us to the end of our presentation, and we still have some few minutes. So let's see if we can try to answer some of the questions that popped up in the chat. See if I can get that up on my screen.
I'm Kim, it's Lily, and I'm trying to keep track of them here.
Yep, okay.
So the very first one, it was related to the requested leave determination slide. It came in from Deborah. And she said, do we know what the notice looks like for this procedure with the department?
Okay, let's see.
That was the
1032 that came in.
Okay. I think I can see the questions. So, yep.
1032, Deb Olson. And she was referring to that requesting leave slide.
Oh,
right.
I see.
The application, I have not actually seen the application. I don't know if Kim has.
I haven't. I don't know if they've published it yet. I think they may have, but I'm not sure that I've seen. I'm sure I haven't seen it. Let's put it that way.
And I don't expect that application form for the employee is going to be complicated. The complication will be for the employer, who has 10 days to fill out the requested information relative to the earnings of the employee and other information the state may require, which some of them is listed in the slide. So, but the state has only 14 days to approve or disapprove the application, and then payment is supposed to come up in 14 days after approval. So within in effect, within a month, the employee is supposed to get more, supposed to get paid under the act.
Oh, I lost my chat. Shoot. Because I had them up, and I like it when I can read them.
Yeah, so it's Kim is the next one at 1043. If an employee takes a 12-week FMLA in the last 12 weeks of 2020, are they immediately eligible for a PFML? Should they?
I think the answer to that, I see that one, right. I think the answer to that is yes, because the law goes into effect January 1st, 2021. The law does not consider whether anyone has taken FMLA in the last 12 weeks of 2020 or anything else. You're immediately available. There's no elimination period. So I would say that, and again, the benefit period for PFML starts when you take that for the first time. So I believe an employee who could have had 12 weeks of FMLA leading right up into 12/31/20 would then be eligible for PFML, most likely, as long as they meet that, whatever the eligibility requirements are for PFML, they would be able to take 12 weeks in 2021. They could take 20 if it's for their own if it's for their own serious health condition, they'd be entitled to the 20 weeks. What do you think?
Right. The FMLA, the federal law, does not prevent you from getting state benefits. So those are two independent. But Kim and I would recommend that you put a person on federal FMLA leave in addition to them being under the state law to use up those 12 weeks. because the federal law allows you to be in concurrent leave at the same time as an exception. Usually you can't be on vacation and bereavement leave at the same time, for example. So you should place a person under federal law, but that doesn't, the fact you are getting your unpaid federal leave does not mean you cannot apply for state leave.
But I think that this question goes to the convergence of the laws for the first time. And I think that that's why I'm saying this. I think if someone is on FMLA in the middle of 2021, because it will then run concurrent with PFML leave, you wouldn't get both. But here, it's because the law is not yet in effect. And that's why you're going to get both.
Yeah.
Next question is, if a parent is home and remote schooling their children as a result of COVID, are they eligible for either type of leave? And I think the person is asking whether there's any form of PFML that allows an employee to be home with their children during COVID as a result of remote schooling. And the answer is no, unless the child is sick. Because in other words, you'd have to be eligible for PFML for one of the reasons. One of them is family leave to care for a family member with a serious health condition. But if the employee is home as a result of homeschooling children, that's not covered by PFML.
Excuse me 1 second, Dee and Kim. It is 11 o'clock, so I just want to we are going to stay on for a little bit more, but for those of you that need to get off the webinar, we will have this recording and I will send it to you along with the slide deck that Dee and Kim put up this morning. So I just want to thank our Fallon Health for sponsoring these series, and I also want to thank Dee and Kim for such a knowledgeable webinar this morning. So with that, we will continue this for another couple extra minutes, but I just wanted to close the webinar on time as scheduled. All right, thank you everybody. And we'll continue with the questions. So Kim, I think the next one is from Kim Miles. Does the notice for fitness of duty, that one? Are you on that?
I see that, right.
That one there, technically, it does not need to be signed by the employee. It's a question of you have documentation that you did forward the employee. And with email today, you can easily do that by email to provide that, and you have a record of whether the employee received it or not. So that but the employee does not have to sign off on the essential duties.
The next slide, the next question I'm reading says, a few slides back, it mentioned vesting. So if someone is out on FMLA or PFMLA, I think with the question mark, it means, can we deduct that time against their service time? So if I'm understanding the question, I think that it is getting to the point that I said, while an employee is on PFML, whatever benefits they had in place remain, so that then we come back to work, they're restored. But during their period of leave, they don't get additional benefit accrual. So I would say if you have to have, X number of years of service or X number of months of service for pension purposes, the time the person is out on PFML does not need to count towards pension, because I think the regulations say seniority. So seniority is like total years of service. And if you can subtract out, or you can hold seniority in place for the period of time the person's on PFML and not accrue seniority, then I would think that you do not have to count the time on PFML towards vesting of a benefit. Dee, do you have a different answer?
No, I agree. They're treating this like workers' comp, that you don't, by law, earn benefits. Obviously, the employer could provide for that, but you're not required to earn benefits, and seniority would be a benefit that you'd be earning. But you can't take away from what the employee had, as Kim mentioned, before they went out on the leave. And when they would come back, they then resume to earn the benefits.
Next question, how does this law work with short-term disability? I don't know if this question goes to short-term disability as an insurance plan. But what is the general policy when it comes to wages? Not per the slide that you mentioned. Okay, so because the slide D was the one that you talked about that said if the company has its own short-term or its own disability policy, they can get paid back from the department, as in the State Department of Paid Family Medical Leave, for the wages it paid to the employee. With an insurance policy, you wouldn't get paid back because that's provided through insurance. But if the question is, how do those two interact, meaning the short-term disability through an insurance plan and the PFML, I would certainly counsel our clients to put the person on PFML or treat it as if it is. Because remember, again, the employer is not really responsible for making the determination of eligibility, but I'd certainly track it as if it were. And I think the regulations say you can't double dip. So whatever you get in short-term disability through an insurance plan, if it's less than what you would get with PFML, then PFML will supplement it. If it's more, then I don't think you get anything more.
I agree.
I want to make sure, I hope that was what the question was getting at. Next question is, can I supplement my vacation time to make up money paid by the state during PFML? So that would be not substituting paid leave, but supplementing. The regulations don't say anything on that, so I would assume that an employer is free to allow its employees who are on PFML collecting a certain amount of money to use their accrued leave to bring them up to 100% of wages if the employer wants to do that. What do you think, Dee?
I would agree. I think that you could do that.
Yeah, it's not required, and it's not really even addressed in the regulations, but I think that's up to the employer and the employee.
Okay. I think we got through them all.
Good.
Oh, that's great.
Yeah, we did get through all the questions there. The contact information's up, so people can reach out to you directly, Dee and Kim, if they have any further questions. So with that, I want to thank you both very, very much for your precious time this morning, helping our members understand a little bit about all this leave. So thank you very much, and I look forward to next webinar.
Thank you.
Thank you very, very much for having us. And again, thanks to Fallon for sponsoring it. Have a great day.
Okay,
Thank you.
You too.
Kim, I'm going to give you a call.
Okay, thanks, Dee.
Thank you.